Hi there, this is Jonathan Ginsberg. I'm a Social Security Disability attorney, and today I'd like to answer a question that I get a lot in the comments of the YouTube channel, and that is, what can I do if I sense that the judge in my case is just unreasonable or unfair? And a lot of people, of course, if they lose, their first conclusion of the judge is unreasonable and unfair. And I will tell you that one of my biggest criticisms of Social Security, their decision-making process, is kind of the arbitrary nature of decisions, in that you may have in one hearing office Judge A who approves 20% of his cases and Judge B approves 75% of his cases. And the hearing office in general is 43%. And to me, it just doesn't make sense that you win if you get Judge B and you lose if you get Judge A. That's a lottery. That's not really justice. And similarly, in some hearing offices, you'll see in certain states, the hearing office itself has an approval rate of 32%. The national average maybe is 45 or 46%. And there may be other hearing offices in certain states, certain cities, where the approval rate may be close to 50%. And it seems to me Social Security has enough cases, they have enough data where they could come up with some numbers to figure out what is a reasonable approval rate for a hearing officer for judges. I don't think it could change that much nationally. And if you see a judge who's an outlier, and this could be an outlier either way, if you have a judge that approves 95% of his cases, that's not good. And if a judge approves 10%, that's not good either. And there should be a way to kind of move those judges out of the system. They're probably not good for the system because their decisions are not representative of what the median is. And by the same token, hearing offices that are consistently below what the national average is, there should be some effort to try to move them to more of the national average, because again, it should be a uniform system throughout the country. Again, that's my criticism. I don't think it's going to change, but that is the fact. That is just the way it is, and that's why I tell people, look up your judge and look at sites like disabilityjudges.com so you have an idea what's going on. Now, that being said, that there's some arbitrariness in the system and I think some unfairness in the system, I think that by and large, most judges that I run into want to do the right thing. What the right thing is may vary, but I don't think there's too many of them that really have an agenda. Very few. I think I've run into one or two over the years at various times who have an agenda that they just want to deny people. And again, it can happen, but I think it's very, very rare. I think most judges approach the bench in good faith. They want to do the right thing, and they want to make fair decisions. But you may walk into a hearing, and I've had this happen to me a couple of times, where it's obvious from the get-go, from the minute you walk in, that there's a hostility coming from the judge. The judge is just unhappy. And maybe this could be any number of reasons for it. It could be he read the file and he thinks that you're a complete fraud. Or he saw there was some evidence in the file of alcohol or drug use and he has a personal problem with that. It could be that judge doesn't like smokers. I had a judge one time, I've been in front of him a couple of times, where if you're a smoker, he will not approve you. And he will always ask the person, how much money do you spend on cigarettes? As if that is in any way relevant, because he's saying, well, you should use that money to go to the doctor to get yourself better. And of course, if you're a smoker, you're not going to have surgery. So he won't approve people who are smokers. That's his thing. I don't necessarily call that being mean-spirited, but that's just something you got to know. If you're a smoker, you're not going to win in front of this particular judge. I had a judge one time who would not let my client bring his service dog into the hearing. I thought that was incredibly mean-spirited. My client was a combat veteran, had served a couple of tours in Afghanistan and Iraq, and had a service dog to help keep him calm when he was under stress. And the service dog was accredited, was fully trained, and the judge wouldn't let him bring it in. So he had to testify and go to this very stressful hearing without his service dog, and then the judge denied the case. And I could sort of tell this judge kind of had it out for this guy. I don't know why. The guy was a combat veteran, had served our country, yet because he had the service dog, that just made this judge really angry. Unfortunately, I don't see that judge. He's in a different city, but I just thought that was really, really unfair. I've had judges in the past when I first started that, wanted to send a message to new attorneys that, I'm going to show you who's boss. And they would try to bully the attorney. And sometimes if it's somebody who I've never been in front of, I still get that. It's less, now that I have all the gray hair, it's less. But it does happen, and it could happen. If you're an attorney watching this and you're a young attorney, be aware that some judges may want to try to show who's boss and bully you a little bit. Maybe the judge is having a bad day. I mean, we don't know. Maybe he had a hearing before yours that went way too long. He hadn't had his lunch. Who knows? But if you get the sense that the judge is just really unhappy, and I've gotten to the point now where I'm old enough, I've done this long enough, where if I get that sense, I'm going to just address it. I'm going to address it on the record. I'm going to be very polite and very cordial to the judge, but I'm going to say, Your Honor, something to this effect. Your Honor, with all due respect, I sense that you're unhappy about something. And if it's something that I've done or my client's done to offend you, I want to apologize. We're not trying to do that. We're just trying to get a hearing of our claim. But if there's something that we have done or my client's done that's offended you, please let me know so I can address that. But I get the sense of hostility that you're really unhappy about something, and I want my client to have a fair hearing. I know Your Honor wants to offer a fair hearing, but I don't know that we can have that with this hostility. And judges will sometimes just kind of step back like, did he really say that? And sometimes they back off right away. If you push back against a bully, they'll back right down and you'll get your fair hearing. Sometimes they'll say, well, counsel, what are you talking about? What do you mean? Well, Judge, when I walked in here, you said X. You were just very, very abrupt with the claimant, and you interrupted the claimant 3 or 4 times when he was trying to talk, or the claimant said he couldn't remember the date he had an MRI 3 years ago, and you became very angry at him. I don't think it's unreasonable that somebody might not remember an MRI 3 years ago. It just seemed like you have some hostility towards this claimant, and if that's the case, again, we'd like to address it because we want to give you the information you need to make a fair decision. But I'm getting that on the record. Because if the judge is being a jerk to me, there's a good chance he's been a jerk to other people. And the appeals counsel, when they see that, it's going to make my chances of winning an appeal that much better. And of course, I don't want to go that route. I'd rather win at the hearing level, and I'd rather get the judge to get whatever's on his in his mind and get it out of there and into the record, get it off his chest. But sometimes you just have to do that. And like I said, I've done this long enough where I know what's supposed to happen in a hearing. I know the way judges are supposed to behave. And if you have a judge who's just not behaving appropriately, I'm going to bring it up and I'm going to address it. I'm going to do it on the record. I've got to represent my clients zealously, and I'm not trying to burn any bridges. But on the other hand, I've got to do what's best for my client. If you're my client, you want to make sure that you get the fairest possible hearing. And if you're not getting a fair hearing, and we're going to have to go to appeal, we want our record preserved for that appeal. So that's what I do. I tend to want to do it myself as opposed to having my client do it, because if my client is there and is saying, Judge, why don't you like me? I think that's a little more awkward. I think it's better if I do it. But again, it hasn't happened very much, and when it does happen, it's very, very rare. And let me also make a distinction between a judge who asks probing questions and direct questions from a judge who's being unreasonable. I don't have a problem with a judge who's asking probing questions. Judges are supposed to ask tough questions. They want to know. And if there's an inconsistency in the record, or if you've lied about marijuana use, or you've lied about drug use, or you've lied about something, or you're lying about work attempts and it's showing up in the record, then that's not unreasonable for a judge to call you out on that. But if there's no reason for the judge to be rude or angry or mean, and he's doing that or she's doing that, then again, I'm going to put it on the record. It's very rare. And again, just because you lose doesn't mean the judge was inherently unreasonable or unfair, but when that does happen, that's how I react to it. I'd be interested to hear what other people might say. If you're an attorney watching this, what has your experience been? What do you do if you have a judge who you think is just out to lunch and is just being incredibly unreasonable and rude and mean? If you're a claimant, it's happened to you. What did your attorney do? What did you think about it? What do you think an attorney should do? I really appreciate the comments, and I read all of them and respond to everybody. So please let me know. Leave it on YouTube. Leave it on Facebook. Like this video if you thought it was helpful. That really helps me. And like it on Facebook as well. Subscribe to my channel, YouTube channel. Like our Facebook page. A lot of great information there. Always publishing on that, on both of these. And if you've not already done so, and you're looking to pursue disability benefits, I've got a free Secrets to Winning Disability Survival Kit. It's on my website, ssdanswers.com, ssdanswers.com. ssdi.answers.com. And if I can be of help to you personally, please reach out to me. My name is Jonathan Ginsberg, and I appreciate your attention. And again, if I can be of help, let me know. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.